Yes, Mr. Claimant.
Just a point I should have made about Underground 1 very briefly. Basis 2 should in any event be factored down by 20% on the basis that the family shareholding was 80% of MRER. This was the point made in Cape.
Well, surely, if we get to basis 2,
yes,
everyone agrees we're going to remit. And
yeah.
The judge will get that right, I'm sure.
Well, I mentioned it only in case your lordship is giving some guidance. But,
oh, I see.
But if you are...
No, fair enough.
Because in that respect...
Factored down by... Well, but that's... Everyone knows that, don't they? I mean, the judge did that on his basis.
Yeah, on basis 1, but my own friend wasn't advancing that on basis 2. It's a fact. I just draw attention to paragraph 18 of Cape and O'Loughlin, where the Lord Justice Latham said that the costs of managing the property owned by the companies in which Mr O'Loughlin had only a 50% share, we had to make allowance for that fact. So, understandably, because it's the property that the dependent has an interest in.
We got the point. Yeah.
Now, Lord, I think I finished on ground 2, and to summarise, just that it's
all right, okay, do summarise. You've got limited time, though, but if you want to summarise, do.
Well, it's the legal entitlement that the court is concerned with. That was what Sir John May was speaking of, not at some sort of discretion or value judgment. It is the legal entitlement, and the shareholding is not the same as a partnership, terminable at will, and indeed, it's never been suggested that Mrs Rix, for example, was holding that shareholding as a nominee or trustee for her husband, or that it formed somehow part of his estate. So that brings me to ground 3, which I think I can be relatively brief about. The point here is that the learned judge, as we've seen in paragraph 106, took off the rental income in doing the final Coward and Comex netting off, but did not deduct or pay any regard to the income that derives from the 40% shareholding still in the hands of Mrs Rix. And we say the point is simple enough that that was not inherited from her husband and was not therefore caught by the exception in section 4 of the...
Is this really a different point from ground 1?
Well, they do merge into each other because they're getting at what the true loss is.
Right.
And but when you get to the point at which there is surviving income, it is conventional to take it into account unless the statute requires you to disregard it.
Well, it depends whether the surviving income was generated by him.
Well, my lord, yes, but if there is surviving income as a matter of fact, and that is the case here, there's no dispute. We've seen the accounts and so on. Then that's partly due to the inheritance of her husband's shareholding, and that is left out of account under section 4. There's no question about that. But it's also, but partly, and half of it is due to her own shareholding, which she always had, and it's not therefore a benefit, to use the words of the statute, which accrues, which has accrued or will or may accrue to her from his estate, or otherwise as a result of his death.
But isn't, by definition, the loss that she's going to recover from the difference between the surviving income and the income that would have been conceptually, depends which route you get there, the benefit she would have had from him making more income for the business?
Well, my lord, because of the 2/3 calculation, or the deduction for, say, living expenses, it doesn't quite work like that. If for example, there was family income of, take a simple example, there's family income of 50,000 a year, and that would have continued had he survived. And the family income is reduced by, let us say, £20,000. So there's £30,000 left. Then the loss of the dependency loss is £2,050,000, but there's £30,000 to come off because that still exists, and that isn't falling foul of any rule about not taking into account events after the... This is conventional. This is what Coward and Comex dictates in this court, that you look at the surviving income because you are looking at the actual loss. So it does make a difference, whichever way it's done, whether it's what we say is the erroneous basis on basis 1, in which case you take off, if you're taking your, as I've put it, I know it doesn't find favour with your lordship, above the line, the gross loss of profit, and then you take the relevant dependency percentage. And if you, then you must take the same thing, like for like, below the line, insofar as it survives in her hands, leaving out of account only that which accrued to her because she is now the legal owner of the 40% shareholding that her husband had, which is caught by Section 4. And it's we say it's as simple as that.
Good.
But I think that's all I need to say on
Thank you.
If Lord Justice Diplock, in a case called Mallion, is quite interesting historically on how benefits were deducted, and of course, gradually the benefits to be disregarded were expanded, eventually arriving at Section 4.
Thank you very much, Mr. Kent. Yes, Mr. Phillips.
My lords, my lady, the issues in this case aren't as complex as my learned friend's submissions would suggest this morning in my submission. He has skillfully created some smoke screens that distract from the key legal points, but I hope my skeleton has distilled them down somewhat, and I'll try and avoid repetition and keep these submissions as brief as possible. As a fact, my lord, as a result of death, the claimant is now entirely reliant on the generosity of her son. Had the company failed post Martin Rix's death, the defendant...
Well, hang on, that's not right. He's then got all the income from the company.
But all the income from the company is generated by her sons.
Well, that may be true, but even that's not entirely true, because she could get in a manager, manage it, and he would make a profit, and she, to the extent of her shareholding, would get the benefits of that.
She could, but she hasn't, my lord.
Well, I dare say, but this way of putting it slightly, doesn't it get away from the essential point in the case? You say not.
My lord, perhaps it's a background point.
Yes, I see.
And I raise it really to address the fundamental point, which from the start of this case, the defendants have said there is no loss. Had the company failed post his death, for whatever reason, the defendant would have no answer to this claim on basis 1 at all. Had the claimant relinquished her shareholding to her sons, which perhaps wouldn't be an unreasonable step to take, given that they are now the ones generating the income that her husband was generating, and therefore it couldn't be suggested in my submission that she failed to mitigate her loss, then the defendant would have no answer to a basis 1 claim.
Why?
Because she would have no entitlement to income whatsoever.
Well, that's because of something she will have done after the death. At the moment of death, she owned, well, doesn't matter what percentage, that's, say, but it is 40, she owned 40% of a profitable company. And
yes,
if she chooses then to give it away, that's something the defendant has to take the hit for.
My only point, my lord, is that had she done that, the defendants would have to raise an argument based on mitigation of loss, and that would be difficult. Given
they wouldn't. Why would they have to? Sure. Is this the hypothesis? I may be misunderstanding you. If shortly after her husband's sad death, she gives all her shares to her children, she's depriving herself, surely, of an asset which survived the husband's death. Why? It's not about mitigating loss. She wouldn't have suffered any loss in the first place.
Well, my lord, it wouldn't be an unreasonable step for the claimant in these circumstances.
Well, it might or might not, but it couldn't be something the defendant had to pay for.
But my lord, my point is this. The income generated by the business, some of which is finding its way to the claimant, is now entirely income generated by the sons. Not the claimant.
Well, is that right?
Is
that right? They're managing it. But what about all the workers and the kit and the equipment?
Well, my lord, that goes to the defendant's point as to whether there is an element of capital asset in the business. They have stepped into the shoes.
The workers. There must be other work. There's not only her sons who are working in the business. Everybody is contributing to the profit, not just her sons.
My lord, the claimant's evidence is that in 2019, which signed a witness statement, there were 17 employees.
Yes.
And subcontractors were also.
Yes.
But my lord, the point is that the sons have stepped into the shoes.
Well, perhaps we're misunderstanding each other. Sorry, I don't want to be coming over being. It's only because I don't understand. If all you're saying is that the sons have stepped into the shoes of their father and are managing it and doing things that he would have done, of course, quite accept that. That's important and very much their credit. I'm not being, and they're obviously doing very well under difficult circumstances. We've seen Jonathan's witness statement. So I wasn't disagreeing with any of that. I just didn't quite see where it got you.
My lord, it's simply factual issues by way of background. Okay. Perhaps if I move on to the approach.
Yeah.
I think to start with why I think the judge was right. The outline.
I think this sort of general stuff, though of course I understand it, and we do all understand the human story behind this, but ultimately we've got to get to the legal analysis.
My lord, yes.
But I certainly don't want anything I've said to suggest that I don't appreciate that the contribution the sons have made in what must have been very difficult circumstances for them. Yeah.
My lord, one area where my learned friend and I agree is when he described this morning that the approach of the court to these cases must be, to a degree, rough and ready, jury question. And that's essentially how I presented the case to Mr Justice Cavanagh. Mr Justice Cavanagh's finding, which you'll find in his order, is essentially that the loss of dependency, the annual loss of dependency, based on profits, our basis one, was something between £64,000 and £75,000 per annum. Initially it was £75,000 in the past, and it's now gone down to £64,000. Now, stepping back and looking at this case as a whole, our basis two, at its core, is based on what Martin Rix, the deceased, might have earned as a managing director of this company. And those were the figures that we obtained from our expert, Julie Hardless. And she came up with gross figures of £117,500 per annum. And you'll see that at page 5 of the schedule. In my skeleton argument for trial, I refined that somewhat down to £62,000 per annum, having taken off tax and national insurance, and also 17.5% as his own personal expenses, which was a finding of fact made by the judge.
Sorry, what's the reference in your skeleton argument to trial, just so I can put it in my notes?
Unfortunately, the skeleton arguments from trial haven't found their way into the trial bundle.
Well, we don't particularly need to see them, but the particular point you were making is one I hadn't fully appreciated. So perhaps it's if you can go somewhere else, we don't need to see the skeleton. You're saying that your position at trial was that basis 2 would have produced an award of £62,500. Yeah.
So rough and ready, the approach the same as what
slightly lower.
Slightly lower.
Not a great deal in it.
Not much in it.
Which might explain how I presented the case, as I think is clear from the judge's written judgment. Now, basis 2 was based on the approach adopted in Williams.
Yes.
And that's why I put it forward as our alternative basis at trial. In Williams, the value of his work to the merchant, the builder's business, was identified and netted down. If I could remind you what Lord Justice Latham said in the Kate case, and it's page 180. Of the bundle, it's paragraph 19. And I'm not sure you've been invited to read that paragraph today. If I could invite you to just read that for me.
Just remind me which tab it is.
12.
I'm very sorry. Which paragraph?
It's paragraph 19.
Thank you.
No, 119. Yeah. Yeah.
As you'll see from Mr Justice Cavanagh's judgment, I didn't strongly press for either basis 1 or 2, because clearly a judge in these circumstances has a discretion as to how he or she quantifies dependency, and they must do it in the way that best fits the facts of a particular case.
Well, you invited him to pursue, you leaned towards basis 1.
I did.
That was the most appropriate basis, and he accepted it.
Yeah. I didn't push strongly for basis 1, though, which I think comes over from Mr Justice Cavanagh's judgment. It remains our case that basis 1 is the most appropriate and most accurately reflects the loss of Martin Rix in these circumstances. But
Well, can we get to the point? You may have detected I find this quite difficult to follow. But where I thought we had got to was that as a matter of principle, C. Wood, and indeed other cases since, Williams as well, you have to distinguish between, on the one hand, income produced by assets which the claimant has inherited, and income attributable to the deceased. And in the case of a family business of this kind, or it had to be a family business, but a business in which the deceased worked and was the moving spirit, that exercise requires you to see what the value added was. And that's exactly the basis on which basis 2 is regularly taken. The value added is what it would cost to have someone come in and do the work that he was doing, someone hopefully of equivalent qualities. But basis 1 doesn't, this is how Mr. Kent is presenting it, doesn't focus on the value added at all. It simply is all the income attributable to his shareholding in the company. And that's a different and less appropriate exercise, isn't it? Because it doesn't focus on his contribution, which is what this is about. Well, do help me, because as you can tell, I don't feel I've got to the bottom of this yet.
my lord, basis 2 is entirely appropriate when there is a genuine mixture of capital asset that has passed on death, and the income from that continues entirely unchanged, and that is Lord Justice Belden, my lord, and I'll take you to that. Basis 1 is appropriate in a case like this, where a judge has appropriately found as the judge and endorsed by Lord Justice Bean in Head also found, that all the profits in a company are attributable to the labours.
Well, that's the bit I don't understand, because how can you say with a company which is asset heavy, it has premises, it has machinery, it has a large, not large, but a significant workforce, that all the profit is attributable to one man? Now, in some more general sense, that is obviously the case, because he built up the whole business from nothing over 20 years. But looking at it in year 20 and at the income of any year 20, you can't say, can you, that everything the company makes is attributable to his work in that year. It can't be attributable historically in some much more general sense. Well,
my lord, you can say that, and that's what.
Well, that okay. Well, that is the essential point. Now, where does ignore for the moment Lord Justice Bean, because that's very recent and elusive. Where in the previous case law has that been said?
Well, in Williams, my submission is that Lady Justice Smith accepted that the merchant builder's business was in fact income generating. It was all the income from that was a product of Mr. Williams's work, and we can see that.
When you say his work, you mean his work over the years?
And continuing. My lord, if we turn to Williams.
But why is that logical? Suppose he'd retired. You could still say all the work, all the money made by this business is attributable to his having built it up over 20 years. True, he's not doing anything anymore, but the others are just coasting on the back of what he did for the previous 20 years. Now, everyone agrees you can't have a loss of this kind after the retirement.
But my lord, what the authorities say, or the examples of capital assets passing, are limited. And they're limited to, as I think you yourself identified this morning, rental properties, where the income has a life of its own. There may be an element of management of the property, but rental property is one, and share portfolio, investment portfolios are another. And the court's approach to these cases, I submit, is that where you have a business that requires day-to-day management to generate any money, that the employees need management, the facilities need management, everything requires management. It would be too difficult to separate out what element of profit is generated by an individual's activity.
I agree, it'd be very difficult, but that's why Basis 2 is so convenient. Basis 2 is a sort of proxy for that.
It is, and it's as I've said from the outset in this case, it's a perfectly valid basis for valuing the loss. We say in this case...
But hang on, it's just chance that in this case you say they come to much the same figure. But suppose the business was much bigger. Suppose it was Microsoft. You could still say, couldn't you, well, Bill Gates built this up from nothing, from his garage in Seattle 30 years ago. And therefore, when he is wrongfully injured, all the income is attributable to his work. Well, but that would be a nonsense.
My lord, I think in that situation, the defendant would have very good grounds for saying, look, given the size of the operation, any one individual cannot be the wealth creator of the whole operation.
Well, I'm not sure about that. Mr. Rix was clearly a wealth creator, and in a sort of general sense, you could say he's responsible for every penny, but in the same sense, you could say this was all Bill Gates's project. He started it, as I say, from nothing, I'm making this up, it may not be his garage in Seattle, but let's assume that it was. Why does the difference of scale make any difference?
My lord, I think it does make a difference in that case, if it were Bill Gates one we're talking about, you would value, it would be a very valuable thing you'd put on his head as the value of services, but that would, I can see, be an appropriate position to take when he is running such an enormous organisation. But in this case, and these cases all turn on their facts, and this case is very similar to the Williams case in terms of the merchant builder's business, not in terms of capital assets outside that, and is very similar, as my learned friend conceded, to the Head and Culver case, which is highly relevant to this case, albeit it was a lost year's case.
You know, quite, I can see it's relevant. So I just want to see what you're saying. So what you are saying it's scale. You are saying that because this is only 20 employees, and because, as I'm sure is the case, Mr Rix was very hands-on and basically knew what was happening all the time, in some sense you can say every penny is attributable to him. Though a time might come, suppose he had half a dozen workshops where that was, you couldn't realistically say that was so anymore, in which case you would only basis 2 would be appropriate. But in this it's really a question of fact.
It's a question of fact.
Which one of these cases are?
Exactly, my lady. And what Mr Justice Cavanagh did was find as a fact that he was the prime mover.
Yeah, but there's no problem about that. I accept that. Nobody's challenging that. No, Mr Kent is. I don't agree with him. He was clearly the prime mover. But you could say again that Bill Gates was the prime mover. I'm looking for the principle that enables you to distinguish between an emotive is the wrong word, a very general term like prime mover, and the rather more precise concepts we've got to use in this field.
The answer is, as my lady said, it's a question of fact in each individual case, and the scale.
What principles are you applying in making your decision of fact?
My lord, yes, and there may be a point where you get to a certain scale of company where it becomes inappropriate. But the companies involved in the cases you have before you here are not of that sort of scale.
Mr Phillips, what you're suggesting is there will be 2 bases. Some cases will be basis 1 case, and some cases will be basis 2 case. Isn't that going to make life? Doesn't that make life much more complicated? Because at the margin, as my lady says, it's a question of fact. And someone will have to decide which it is, and that will lead to more litigation and more argument. And that's the first point. But basis 2 could be applied to all cases, whereas basis 1 would only be applied to a certain shareholder.
Well, my lord, yes, and that's an issue that judges have to wrestle with.
Well, wouldn't it not be easier as a matter of pragmatics to have basis 2 in every case?
My lord, not where the facts are, as in this case, where the profit, the dependency is fixed at date of death. There is nothing that the dependents, or for that matter, any other third party can do to change that. And it's clearly identifiable what the deceased was generating by way of income. And he was generating it as a finding of fact.
Yeah, really. I'm just trying to get at, not looking at you, I'm trying to get at the principle. To say he was generating it begs the whole question. In what sense can you say someone is generating the work of a medium-sized organisation, of which they are certainly the head, of which they are certainly the founder, but they can't have their eye on every contract, they can't be drilling every screw themselves. You just say question of fact and degree in this case is one that Mr Justice Cavanagh.
And he was entitled to find.
Yeah, well, perhaps that's all it is, and we'll have to see whether we accept that. And the oddity is, it doesn't really make very much difference to you if you're right about the figures, because as it happens in this case, basis 1 is very like basis 2, only a few £1,000s in it.
Overall, I'm very concerned about what my learned friend's going to say about basis 2 if we end up back there in terms of deduction of.
No, I see. Of course, you've got this. You've got to win on this basis, and you want to defend it. But I'm just trying to detach myself from the facts of this case, where it doesn't ultimately make very much difference if you're right about the figures, to one where it might make a very big difference. But there we are. You can only deal with this case, I do see.
Absolutely, my lord. And if it were one can imagine if we're looking at the Bill Gates situation, the value of Bill Gates's services, one can imagine on basis 2, that would be a very, very significant claim in any event.
It would, but it would almost certainly be less than giving him the whole of the profits of Microsoft for that year.
Depending on where Microsoft are at that time.
Mrs Rix might be wondering where this is going, or regardless of Bill Gates.
No, I know, it's
She wouldn't be in the back of the court.
we do appreciate this is a real life situation, but I'm sure Mrs Rix appreciates we've got to understand whatever principles we lay down have got to apply to a whole lot of different situations, and that's why we're taking these rather extreme examples just to test what the principles are.
My lord, yes. And what I would say is there's no significant element of MRER as a business that could be described as an asset capable of generating income in itself.
You're basically saying, is this a way of putting it, MRER could not generate income, any income, without a figure, without Mr Rix or an equivalent figure at the helm. And therefore, all income generated in a particular year, profit, let's just call income for convenience, all income generated in a particular year must, for Fatal Accident Act purposes, be attributed to that figure.
And my lord,
Can we perhaps just test it this way? Suppose, in fact, the whole business had been sold to another person with equivalent qualities to Mr Rix, with his flair and commitment and hard work and all the qualities he clearly had. And a year later, it had been, and he had a wife and family very much like Mr Rix does, and a year later, he'd been killed in an accident for which someone was responsible. Would your submission be the same, acting for his widow? He wouldn't have built the whole business up, he'd just written a cheque for it a year previously.
it would be that the
would have to
claim on behalf of his widow would be the same. It would be
Yeah, so it's not really a question of him having built it up. It's a question of it being an enterprise which is entirely dependent on the running of a single person, however competent managers he may have at the next level down. Okay.
It's his earning capacity
Well, I'm just
at the date of death. And expectation, obviously, going forward.
Okay.
And I suppose applying it to the facts of this case, which in the end one is going to have to come back to, one could look at what happened in 2015. It was his entrepreneurial, if you like, approach that led to the buying of a bigger building, which would lend itself to bigger contracts and undertaking bigger work. That came from him.
It did, my lady. And one could, what we've avoided doing is speculating as to exactly how the profitability would have increased in the long term, because that involves too much speculation, and that's what the courts want to avoid. And my learned friend's position...
That's not entirely right, is it? Mrs. I've forgotten her name, the accountancy expert, did actually, the speculation was rather modest, but it was much. She built in a, 4% growth, I think.
up to date.
That's speculation. You might say it's cautious speculation, but it does involve her taking a view. And if you could have argued for no, it would have been 10%, 15%.
But of course, what my learned friend's asking you to do is, or asking the court to do, is to speculate long term and just identify the difference between what now the sons will generate and what Mr Rix would have generated.
Well, is that quite right? Basis 2, which is really what he's having to fall back on, I think, really acknowledges this difficulty of speculating and says for that very reason we won't speculate, we'll just say this is what these services would cost to buy in the market. It's not an ideal, nobody suggests it's the same, but it's the best way of putting a monetary value on something that actually is unquantifiable.
My lord, yes, but under basis 1, and this is the simplicity of basis 1, applying the law, the dependency is fixed at the date of death. There's nothing that anyone else can do to alter that dependency. And so there is that degree of certainty. And because Mrs Rix was not involved in the business in any active way whatsoever, the calculation of loss is straightforward. Because the profitability of the company was, as a matter of fact, attributed entirely to Mr Rix's endeavours.
And those were the findings of fact by the judge.
Lady, yes.
And that is why you favoured, as I understand it, basis 1, because on the facts of this case, it was the straightest line through.
My lady, yes. And that's the way the case was put until a relatively late change in the case to put the alternative basis.
What, basis 2?
Basis 2,
yeah. Because
we realised that the case was being vigorously defended, and that was the only reason basis 2 went in as a sort of safety net. Put it like that.
And because, yes, and it's an attractive safety net, it's not the one you're arguing for, because you can immediately point to authorities which look similar. You're going to say they're not similar enough, but look similar and say this is what the courts have done on at least 3 previous occasions. So I can see why it's an obvious safety net. And actually, if you're right on the figures, it doesn't make much difference, but it's nevertheless not the primary way you're putting it.
And it's probably here relevant to mention that the original claim in the Williams case was put on a basis 1. And we can see that from the...
Speaking for myself, you must do it as you wish. I think now, having had this very helpful exchange, which has helped to clear my mind a bit, the sooner we go back to those cases and see how they, as it were, fit in with your way of putting it, speaking for myself, I'd find that helpful to do sooner rather than later.
My lord, if we go to Williams then, the paragraph 14, page 246, this sets out the original claim.
Yeah.
And that clearly included the profits of the business. It was obviously complicated by the property portfolio, and that may have played a role in the decision to amend the claim as set out over the page at paragraph 15. But there's a significant difference in terms of the dependency, and I think I have to explain why in this case you only have Mrs Rix before you as a dependent. In the Williams case, there were 2 children involved in the business, the merchant builder's business, at the time of death. But they all received an equal share in the profits. And they received something like £100,000 each on the basis of the profitability. But as can be seen at paragraphs 4 and 5, at page 244 and 255, the economic value of the children, and indeed Mrs Williams, who also received the profits, was way below that. One of the dependents was paid 15,000, or the value of the labour was 15,000. and Mrs. Williams, the other was about 15,000, and Mrs. Williams was about 3,000 per annum. So they were financially dependent on Mr. Williams at the time of death, because they were being paid way in excess of their value to the business because of his endeavours and the profits he was generating. Now, it won't surprise you to learn that we carefully considered whether the sons, Jonathan and Adam Rix, in this case, should be included as dependents. But we came to the decision, as a legal team, that they probably aren't dependents, and the defendants would probably successfully resist any application to bring them in as dependents, because both Jonathan and Adam Rix, at the time of death, were being paid the going rate for their services. And as you'll see from the facts of this case, the plan was for Martin Rix to continue working full-time until he'd seen off the mortgage on the new building, age 74, and then probably start handing over. But they had no expectation of receiving anything more in terms of profits from the company until that point. So we took the view that they were not financial dependents, hence you just have Mrs. Rix as a dependent in this case.
Thank you, that's clear. Yeah.
Now, that's the significant factual difference between this case and the Williams case. But if I could take you to paragraph 37 at page 252. This is where Lady Justice Smith deals with what the first instance judge said in this case. She identifies that the judge turned to consider what the position would be in a case in which the deceased's income before death had been derived partly from capital and partly from his labour. This was relevant because this family's support before the death had derived partly from the capital Mr. Williams had amassed and partly from his work as manager of the business.
Yeah.
Now, you'll remember that Mr. Williams had built up a portfolio of properties and also some steam engines and factory machinery. What one assumes it was antique factory machinery rather than modern. But there's a clear distinction, we say, between income from the business and capital asset.
Right. Well, you're probably right, and that's important for the way I've been thinking about it. But yeah, I think you will have to make that good, because it's not clear from that sentence that by the capital, she's meaning only the property portfolio and the steam engines. The capital could also be the capital value of the business.
Well, my lord...
But you say it'll become clearer as we read on.
Well, there's certainly no mention of the capital in the business generating income itself. And if one... The only further clue, I think, is at paragraph 46, which starts at the bottom of page 256. And then the top of page 257. And it states, consider the children's position. At the time of death, David and Sarah working in the business doing jobs with an agreed economic value.
So, sorry, you've got ahead of me. Which paragraph?
Paragraph 46.
46,
bottom of page 256.
Yes, I have it now, yep, thank you.
It's over the page is the more relevant part of the paragraph. The reference there is that the answer was because their father was generating large profits by his management of the business. And instead of taking out a large salary for himself, he could have justified giving them far more than they were earning. Again, there's simply a reference to the profits in the business. And we say there is no, in Williams, the distinction is drawn between the merchant builder's business and the rest of the assets.
We've got the first instance decision in Williams as well, haven't we? Does that...
It doesn't really take anything, it doesn't, in my
clarify,
submission,
clarify
clarify
the point you're making about the distinction
yes, there would be.
different assets?
Can we look at it? Because there was a passage which in fact we needn't look at it because where there's the long passage quoted by Lady Justice Smith at paragraph 40, page 254 in the bundle, 65. Which I took in a different sense, but perhaps wrongly. You see the passage that's been italicised. What the dependents have lost is not income derived from a capital asset. And I read Judge Hickinbottom there as referring to the business, not to the property portfolio or the steam engines, but the contribution of Mr. Williams as the manager of the business and family assets, including property and steam engines. I'm not sure. Does this help you? Doesn't it rather look as though certainly what Judge Hickinbottom is doing is not distinguishing between the property portfolio and the steam engines on the one hand and the business on the other. He's looking at all three of those things and distinguishing between the capital and the value that would naturally generate, the rental from the properties or the income from the portfolio, and the added value given by Mr. Williams's flair, expertise, and energy.
My Lord, I would submit that on the basis of what's in the first instance judgment and what's in the Court of Appeal judgment, that the only identification of assets is in relation to the steam engines and the property portfolio and the farming machinery.
Yeah, well, I need to look at it more carefully, but I mean it is important to understand this is what you're doing. You're showing us Lady Justice Smith and indeed therefore Judge Hickinbottom, because she basically agrees with everything he says, doesn't she?
Yes.
Yeah. See exactly, when we look at the figures, it may become clearer still.
And my Lord, there is a total absence of any suggestion or analysis of the business being in any way a capital asset. And I rely on that absence. And my Lord, what Judge Hickinbottom is focusing on here is, and this is the whole point of applying basis 2 to a case such as this, you don't have to divide up earned income and income from assets. And so it was not suggested, because of the way the claim had been amended, it was never suggested that he had to look at the profitability of the company. And my Lord, the head case is highly relevant in this situation as well. Because, and my learned friend is obviously only too familiar with the business in that case, having represented the defendant. But that was a substantial business. My learned friend described it as similar to this case. And we say it's absolutely clear what Lord Justice Bean was describing as the receipts of that company. And if we turn to that, paragraph 33, which you've obviously already been taken to, page 352. But having been taken to Mr. Justice Cavanagh's decision in this case, He states, as Cavanagh J did in the Rix case, I consider that at the time of Mr Head's death, all the income which he and his wife received from the company, save for the small deduction in respect of Mrs Head's work, was the product of his hard work and flair, not a return on a passive investment. Now that goes to the core of the issue, my lord, you've identified it in this case. And it goes on to state at paragraph 34, Mr Head was free to dispose of her income in whatever way he chose. Now what my learned friend has done is jump on the fact that he uses the word received. And to suggest that he's only there looking at income actually taken from the company in any 1 year. And that simply can't be right, because he specifically refers to the first instance decision in this case, where Mr Justice Cavanagh clearly referred to the whole profitability of the company. But it goes further than that, because at page 342 of that judgment, there is helpfully set out Judge Melissa Clark's first instance decision, at paragraph 93 of that decision.
Down at the bottom of the page.
Down at the bottom. If I could ask you to read that.
Yeah, it's really only the first sentence, isn't it?
It is really. And what she
There's a
refers
separate
to
point
is
about Mrs Head. Yeah.
real loss of earnings or earning capacity. And that includes 90% of EMSL's profit after directors' salaries and corporation tax. And so that's clearly based on...
Remind me why 90% rather than 100%?
It's 90% because they each held 45%.
Yes, I see.
And at the bottom, back to page 352, paragraph 34, I think Lord Justice Bean does in fact clarify what he means, in that he refers to earning capacity.
So which paragraph are we on?
Paragraph 34, second sentence. It's the second half. That would be to mischaracterise the nature of a lost year's claim, which requires assessment of the value of the earnings or earning capacity. Must include all of the profits in my submission. And we also derive encouragement from the fact that Mr Justice Johnson has, since this decision, in May of this year, been asked to resolve this issue, as my learned friend conceded, and found in favour of the claimant's characterisation of what Lord Justice Bean said, and allow 90% of the overall profitability of the company. So Mr Justice Johnson clearly would endorse my submission at this point. And that must be right. Because my learned friend's skeleton argument purports to suggest that any element of profit that's retained in the company somehow reflects a return on capital asset. And I hope I've made clear in my skeleton argument that that is an entirely arbitrary line to be drawn and frankly unsustainable. It's an investment decision which may be influenced by any number of matters.
Sorry, will you make that submission again? I was just reading something the judge had said. My fault.
My lord, my learned friend's skeleton argument suggests that the element of profits retained in the company from year to year should somehow be deemed to reflect what the true return is on the capital asset element of the company. That's certainly my reading of his skeleton argument, and I've addressed that in my skeleton argument, saying that there's absolutely no basis for that whatsoever. That's an investment decision, depending on what income's required that year, what the taxation position is, whether it's a good idea to reinvest in the company. But that it exposes the flaw in the defendant's position that there is an element of the company that generates income without any element of management.
Sorry, just say that again. There's an element of the company.
There's any element of the company that's capable of generating income without any element of management. And, my lord, the defendant's position that one has to look at the profits actually generated since death and received by Mrs Rix, it does clearly fly in the face of the clear legal position identified by Lady Justice Smith in Williams, that nothing done post-death can affect the dependency, other than death. And my learned friend in his skeleton argument for today set out an extract from McGregor, which simply isn't the whole picture. It refers to Williamson, which is in the bundle. I don't think I need to take you to it, because in that case the issue was the dependent dying post-death and bringing an end to the dependency. Well, we accept that that is a relevant post-death issue. The other case was Kerwin, which was briefly discussed, but that of course was dealing with remarriage of a dependent, which at the time Kerwin was decided was a relevant issue in dependency claims. But that's been obliterated by Section 3.3 of the Fatal Accidents Act. So in the remarriage of a dependent, it is now an irrelevant consideration in the dependency claim. So those are the only two exceptions identified.
Is
And
that
one
right?
of those
I mean, what about the case where the claimant who had where the deceased who had a life expectancy of 20 years at the date of the death, and if there'd been a trial on the date of the death, would have got damages on that basis, unexpectedly dies a year later before trial?
if the dependent does, yes, that brings an end to the dependency.
I wasn't a dependent, a claimant in a non-fatal accident,
personal
an ordinary personal injury case.
Oh, of course.
Well, exactly, but why is the principle any different in a fatal accidents act case from what it is in ordinary common law cases?
It's not. If the dependent has died...
No, but that's claim.
So, my lord, I may be misunderstanding...
No, well, maybe I'm getting at a broader principle that normally in common law damages claims, you have regard to events which occurred between the date of the cause of action accrued, an injury, let us say, and the date of the trial, even though they were unpredictable at the date of the trial, at the date of the injury. Why should that be different in a fatal accidents act case? I'm not just talking about the dependent dying, but there could also be other events which have affected the quantum of the dependency.
Well, my lord, remarriage was one of them, but that's now by statute been removed. And I could take you to section. We have section 3.3.
I believe you. I'm sure it's right.
But my lord, in terms of this case, I don't think there's any criticism of Lady Justice Smith's characterisation of the position that there's nothing that can be done because the dependency is fixed at date of death. other than the effects of inflation as well. There's death and there's the impact of inflation. And that's why, on basis 1, my learned friend's submission that there's a need to look at what's actually happened is legally unsustainable.
Sorry, we got into this by you accepting my invitation for us to look at the trilogy of cases which Mr Justice Cavanagh distinguished in deciding not to follow basis 2. And you took us straight to Williams, which is the most recent. And I think, had you finished, your submission on that was that the reason why basis 2 was more appropriate was that the income was generated from 3 different sources, only one of which involved Mr Williams's labour. And you say if we read the judgment carefully, it'll be clear that that was the basis of the distinction.
Yes, my lord.
I would like to think that was so, and I will read it carefully. Didn't jump out at me when I read it first, but you're probably right about that. How would you deal with them with the O'Loughlin?
The cake case was
case.
I was just coming to that, my lord.
Okay, that's helpful.
My learned friend relies heavily on the fact that in Cape, loss of profit wasn't pursued, and it was purely a basis 2 claim. Well, my lord, it's quite clear why in that case, because the business was essentially management of a property portfolio. And so, self-evidently, an enormous amount, well, the income from that property portfolio continued post-death.
And would have continued without any need for a manager at all?
Well, no. And so the claim was put on the basis of what does it cost to replace the deceased services as a property manager.
I expressed myself badly. Of course, you'd still need a manager to follow up on rentals and so on, but it's much more of a passive business than running a trading business. That's really the point.
Yes, exactly.
It's about passivity, which is what Lord Justice Bean focused on.
That's right. We would say that's a capital asset case, and we see, those of us who work in this area see cases like that very, very frequently. It's rental property. The property passes. You claim the value of the deceased services to that rental income, and that might be by way of simply paying a managing agent.
Yeah.
And that's a very common situation. Less common is the situation that the court faced in Williams and in this case.
So there'll be a spectrum, won't there? There'll be a range of cases, in which some cases like the sort you've just been talking about, property companies where the answer's obvious, and other cases at the other end of the spectrum where the answer's obvious the other way. But there'll be quite a lot of cases in the middle, and someone's going to work out whether it's a basis 1 or basis 2 case.
My lord, yes, and I understand your concerns.
That'll be you and your learned friends, no doubt. But is that the way these cases should be approached?
The difficulty is, and I can see your attraction to the idea of one principle to apply to all these cases, but they are so factually different, and that's the difficulty. That my submission is the courts have just got to wrestle with them on an individual basis.
And that's what we see starting with Wood, isn't it? Both Beldam and Staunton, LJ, they are emphasising the factual nature of these cases, and the courts in the circumstances have to do the very best they can. And it may well be, I'm not saying it is, that one strict rule simply will not apply to all and result in some injustice.
My lady, yes. And Wood is a good example, because that is a very complicated case, actually. No matter how many times you read it, but because of the farming business in question. But I think since Wood, things have become a little clearer. But it's just one of those areas of the law that has to react to the factual.
Can we just see finally the final of this trilogy? See Wood, and just look again at what Justice Staunton said.
The new edition, the new version.
Yes.
The new
Yes, using the one that Mr. Kent handed up. The key passage from his purposes is.
My lord,
Well, now, can we just look at the boarding house case between the two hole punches on the final full page? One turns to the case where the income is in part derived from labour and in part from capital. Suppose the husband owns a boarding house and he and his wife run it together. If he should be happened to be killed by an agent wrongdoer, the widow inherits the house and continues to run it. Should she recover to the extent of her dependency on the whole of the profit of the boarding house? Not very different from the present case. My answer is almost again determine what the dependents have lost. The court has to ascertain how much loss has arisen because the deceased is no longer alive and able to work, and how much of the deceased income was derived solely from capital which the dependents have inherited. That's a bit cryptic, but how do you say that plays out in the case of the boarding house?
well, my lord, I think that's similar to. I've got to remind myself which case it is, but was it Kent, the BRB, where you have a joint enterprise?
Yeah.
And so you can only claim 50% because it's a genuine joint enterprise. My learned friend relies on the joint enterprise case.
When we get to ground two, but let's just stick on ground one.
And that's clear. It's 50%. You can't claim the loss of 100% of something that your labours are contributing 50% to.
Is that the only point that he's? Is that the point that he's concerned with here? Is he concerned with a different point? Have a look.
I confess I'm not sure where Lord Justice Staunton is going with that hypothetical situation.
As you say, the facts are extremely complicated because the children did have some fields in which they received an income.
But the real one of the issues that we place great reliance on is at page 12 of the PIQR report, where Lord Justice Belden states, no doubt where a dependent claims for loss of the expectation of pecuniary benefit, which is the very thing which the dependent is enjoying as a result of death, it can, as in the case of the eldest son in Pym, be said that there has been no loss or no injury. In this case, my lord, and this is a relevant distinction when considering capital asset versus earned income, MRER as a company is simply not the very thing that existed when Mr Rix was in charge. It's a very different company. And Mr Justice Cavanagh's judgment sets out in detail the central role he played in that company. This is not a property that continues unaltered. It's not a share portfolio that's entirely unchanged.
It's a business to which the work of the moving spirit is integral. Yeah.
My lord, I think I've dealt with the key authorities there. I'm not sure there's a great...
I can't speak for my lord and my lady. I feel I see exactly how you put your case on ground one, and I don't think I'll benefit from any further submissions on it, but they may. Sorry, it came out wrong. But,
my lord, in terms of grounds 2 and 3, I think I can be very brief here.
Yes.
Because in terms of ground 2, this is a Ward and Newell's case. Effectively, I would say it doesn't matter how you characterise Mrs Rix's status within the business. I would say, given the factual evidence, she's effectively a nominee share, or was a nominee shareholder of her husband. And it is simply there's no legal distinction between the partnership in Ward and Newell's and in this case. And this is clearly not Kent versus BRB. It's clearly not the Neal case. One only has to cast a cursory eye at those cases to see that they were 50-50 joint enterprises. And that was found to be the reality of the situation. They are of no relevance to this case whatsoever. No part of Mrs. Rix's income by way of salary and dividends prior to Mr. Rix's death, or since, in fact, is her earned income.
From the company.
From the company.
Let's not forget all the other things she does that aren't.
Absolutely. And that has been dealt with in one of the authorities, I believe. I can't remember which one. That as a husband and wife, they were a joint enterprise. And there's no doubt she enabled Mr. Rix to earn the money that he did, as in many such husband and wife relationships. But that is not a relevant issue in terms of identifying his earning capacity and what he actually brought into the family coffers, as it were.
Of course, the court accepts that, but we are very, very conscious that Mrs. Rix is listening to this, as is Jonathan. And I wouldn't want either of them to think that we don't understand that when we're dealing with legal concepts, we do not forget within it our individuals and the personal contribution they have made over the years.
Obliged for that. And that brings me into ground 3, the Coward and Comex point. Because the key issue in terms of ground 3 is that the defendants are seeking to characterise Mrs. Rix's continuing income from the business as her income. And as I hope my skeleton argument makes it clear, that doesn't stand up to even cursory scrutiny. The Coward and Comex case involved a husband and wife who had very, very different and separate income streams. He was a professional diver. I should probably say commercial diver, as opposed to the Top Daily type diver. She was a midwife. He earned X, she earned Y. The way you calculate her loss in those circumstances is to add X and Y together to give you the family income. Standard rule of thumb, take 2/3 of that, assuming that he would spend 1/3 on himself, the deceased. That leaves you with the income that she enjoyed the benefit of, but then you have to deduct her independent income. And that gives you her loss. But what is absolutely clear is X and Y are entirely independent income streams. And that simply cannot be said in this case, where it is quite clear that all the profitability from MRER is generated by the deceased. And her income from MRER now is, which brings us back to the start in a way, is entirely dependent on others. And by definition, obviously insecure. It depends on the health of others, the ability of others, her relationship with others. But crucially, it's not generated by her own labours. And as I indicate in my skeleton, if one, that the fallacy of the defendant's argument is also demonstrated by the application of Section 4 of the Fatal Accidents Act to this element. Because if it's held as a matter of fact, which it must be in this case, that pre-death, all the income from MRER was his earned income, whatever she receives post-death has to be, if it's to be deemed her income, must be disregarded under Section 4 as a benefit resulting from death. And so I say that's the end of that. That blows a hole beneath the waterline in the defendant's position. I harbour concerns that if you are against us today in relation to basis 1, and we are remitted back to the judge on basis 2, my concern is that it appears from my learned friend's skeleton argument that they are going to seek to apply a Coward and Comex calculation on basis 2, which was not performed in any of the other cases, and for the reasons I've just outlined would be wholly inappropriate. But it may be, I'd rather not join battle again on that issue, and it seems to me...
Yeah, well, I see that, of course, practically, but I mean, the truth is, if it ought to be basis 2, and if you're right that basis 2 shouldn't be cut down in the way that he suggests, you have to trust the judge to do the right thing. But you'd rather not.
Of course.
Yeah.
My lord, my lady, unless I can help you further, those are my submissions.
Now, let's be very clear. Just with all that behind you, come back to how you would deal with a layperson, treat me as a layperson for these reasons, who says, well, this is all very well, but the fact remains that the business is making, and maybe, let us say, could be predicted to have gone on making more after Mr Rix's death than it did before. Why is it right that you should receive compensation in those circumstances?
My lord, because it's largely down to Jonathan Rix,
well,
and his labours.
Well, that I see, and then you would meet that surely by saying you should pay Jonathan, you should have compensation that would reflect the value of what it would have to be paid to Jonathan for doing what his father would have done. So it should be basis 2.
My lord, no. One other way of looking at it is that, as in, and it's in the bundle, and I referred to it in my skeleton argument below, you may take a view that this is a Hunt and Severs type case where you are recovering monies and holding them on trust to pay to the provider of the services, the person who's replaced the services. Hunt and Severs was a care service.
Yeah, I remember Hunt and Severs. Yes, but I mean, so you're saying that this is, in some broad sense, what I'm pushing to you is in some sense, broad sense analogous, yes? But why is that an answer to my point?
Mrs Rix is compensated and she holds it on trust to pay the person who has actually stepped up and replaced.
Yes, but that's only because basis 1 and basis 2 are, as it happens in this case, quite similar. But let us suppose that basis 1 recovered you 2, 3, 5 times what Jonathan should have been paid to be his father's equivalent. You then still have overcompensation. What most accurately meets the loss that has been suffered, because I don't think any of us now at the end of Mr. Kent's submissions are saying there's no loss here. It's a question of how best to characterise and quantify the loss. If it's the loss of the man who made it all happen, can't you pay someone else to be the man who made it all happen?
Well, my lord, you could, but it doesn't mean you have to. You're entitled.
Isn't that the most accurate way of doing it?
But my lord, also, if you take your example of if basis 1 meant you recovered 2, 3, 4, 5 times more, that would tend to undermine your argument for basis 1 over basis 2, because we might end up in the sort of the Bill Gates analogy situation.
It's difficult, but you have made it extremely clear, and I won't pursue that line with you any further.
Is there any part of your case that you think that Mr. Rix's influence on the company goes on after his death? Does that, just as Bill Gates is going to carry on, go back to Mr. Gates, his influence on Microsoft is going to continue for year after year. Mr. Rix's, Martin Rix's influence on the company continues long after his death. I was struck by the fact they've just moved into these premises that he'd been building up to. He'd been looking forward to it so much. That was part of his legacy. So, is that part of your? Is that an argument in favour of basis 1?
It's not an argument that we've employed because of the difficulty in predicting how things may have gone.
But I also think you disavow it. At one point, I rather put words into your mouth that this should all be treated as the dependency because the whole business was the result of his work for 20 years. But then I said, well, if that's so, shouldn't there be a different answer when someone just writes a cheque and buys a business and then the same thing happens to them? And you said, no, the answer would be the same. The result of that, I thought your focus is really on the fact, no, year by year, irrespective of what may have happened in the past, on facts like this, his income is the same as the dependency, or the income that generated while he was in charge is the dependency, irrespective of whether he bought it last year or built it up over 20 years. Have I got that? I think
yes,
that logically seems to me a better way of looking at it.
And it's fixed at death. That's
and fixed, of course, yes.
No, thank you.
Thank you very much, Mr. Phillips. Yes, Mr. Kent.
My lords and my lady, first point, my friend, seizes understandably on my concession that it is a rough and ready process. It's a jury question. Precision is not always to be expected. Nevertheless, if this doesn't amount to carte blanche, if the judge decides an approach that is appropriate and then follows in detail the calculations set out in a forensic accountant's report, then the question is whether that process, which produces very exact figures, is itself flawed as a matter of principle and conceptually. And that's our complaint here. My learned friend says that, I think perhaps hinting that a way of dealing with this appeal would be to say, well, the judge got the right answer even if it was for the wrong reason. Says that basis 2 would produce much the same result, and we don't accept.
No, to be fair, I don't think he was saying that at all.
I apologise to my learned friend, but sometimes that is a perfectly proper response to an appeal. I should just say this about basis 2. The calculation, which he said produces a slightly lower result, did not involve, in his final skeleton argument, which isn't before this court, did not involve any credit even for the rental income that Mrs. Rix continues.
Well, we're not going to get involved in any of that. If we decide it should be basis 2, we're not going to put a number on it.
Thank you. Well, that's helpful. Williams, my learned friend suggests that if one looks at Williams, there isn't, in fact, such a difference, even though I have submitted that the whole point about Williams was that they were avoiding the gross profit approach and looking at the finding a way in which one could assess the value added by reference to the cost of replacing Mr. Williams's services. And one sees that in paragraph 8. If I could just take you briefly to Williams again, tab 13, I think. Sorry, tab 15. Paragraph 8, I've taken the court to this. There's a reference to the business profits, and that appears to be the profits of the merchant, builder's merchant business. Gross profits of a business profit of £384,000. And we know from paragraph 9 that I think there were 4 partners, and they were each receiving something like £88,000. So one sees that there was quite a lot of money coming out of the business to be distributed. And it is very clear, therefore, that when the claimant, having, as it were, abandoned, as my learned friend rightly says, the original approach, which was to look at the profits of the business and focus on the cost of replacement, we see in paragraph 15 that what is being claimed is a replacement at £87,500 a year, which actually is represents what a single dependent was receiving from the profits of the business. So there's no question of this court having somehow approached the matter in much the same way as Mr. Justice Cavanagh did in this case. And of course, Lady Justice Smith, as I've made clear more than once, in paragraph 51, says that any other method of assessment would have been difficult and complicated because of the need to separate out the income which is derived from capital from that which was derived from labour. And given the figures I've just taken the court to at the beginning, that must include the builder's merchant business as much as the purely property elements of these activities. And so what the court is doing in cases like Williams and Cavanagh is finding a loss and using conveniently the cost of replacement as a proxy for that loss. So that is the loss to the dependents. And then it's reduced, once you get the replacement cost, it's reduced by the notional tax that would have been payable by a replacement for deceased, and then by living expenses and so on. And so that is a way. This isn't some extra statutory scheme for assessing loss, which bears no relation, assessing dependency, which bears no relation to loss. It's simply a way of, as a matter of, in finding the fact on the balance of probabilities of what the loss really is. And when my learned friend says all the profits of the business, this business, MRER, are generated by Mr. Rix's efforts, leaving aside the historic aspect of it, which we readily acknowledge and have acknowledged, we say that that the evidence clearly did not support, and the burden of proof is not on the defendant on this, did not support a conclusion that every penny of the profits arose from his continued day-to-day attendance at the business. For obvious reasons, he has...
Well, you say for obvious reasons, it's a question of how you look at it, isn't it? I mean, I put to Mr. Phillips, I think essentially the point you're putting to me, that any business, however much driven by one man, is actually the product of the hard work and commitment of all the employees, but some certainly will be doing things which you can say make a real difference to the profitability. But that may not be the only way of looking at it. You may be able to look at it in a broader way and say there is still a business, and the argument may get weaker the bigger the business gets, but there are still kinds of business which do employ 15, 20 employees, but where you can realistically say this is all really generated by one man. Yes. The rest are just, I don't mean this in any way rudely, but they're all just working completely to his direction and don't have independent profit-making ability. Now that's a bit of a common sense way of looking at it, but it's not an unrealistic way, is it? And then it just does come down to a question of fact. Was this such a business?
Yes, but what I'm going to submit in a moment is that the facts contradicted any conclusion that it was 100% his effort on a day-to-day basis that was producing the profit.
Well, which facts?
Well, the business has a substantial factory. It has a workforce and subcontractors whom it employs. It has goodwill, client lists, customers, loyal customers, and so on.
But you're just feeding back to me the point I just acknowledged already, that in one sense, you look at a business like this, you can't possibly say it's all the work of one man, because he has to use other people, and they work hard too and help to generate the profit. But in another sense, you can say it's all the work of the profit is all the work of one man.
Well, historically, one might.
No, forget even historically, even in the year in question.
Well, that we would say would be wrong, because for example, if one could turn to page 6 of the supplementary bundle, it is argued that the future loss of income will include income from a 20% shareholding, which he would retain after he retires at 74. Well, that's an acknowledgement that it has, unsurprisingly, an income-producing value. And although it's not a listed company, so it's not easy to, no doubt, to sell the shares would have a value. And the reason they would have a value was because of his efforts to build up this substantial business and acquire these assets. And a loyal workforce. Mr. Jonathan Rix understandably emphasised how he was under strain taking over so suddenly and without the transition period that would otherwise have been expected, the duties of management. And he said he thinks that contracts have been lost. He thinks that the business would have done better if his father had been there. And one can well understand that. But that's not saying that the business stops, as it does with, say, a successful actor or author or broadcaster or whoever, barrister, who may have incorporated his business, who is the business, and where it stops when he ceases. And that's why I took your lordship to Lord Justice Bean in Head, giving the example of the position if Mr. Head had retired early and lived off the dividends. And my learned friend focused on paragraph 34 of Lord Justice Bean. Perhaps I could just answer that. This is tab 20. Paragraph 34. He said Mr. Head was free to dispose of that income in whatever way he chose. By contrast, as Mr. Steinberg rightly observed, he could not make a testamentary disposition of his own future earning capacity. Now, but of course he could make a testamentary disposition of his shareholding. Now, if that had no value, that would be no use. But that's the question in the case. Does his shareholding fall to nothing because he is no longer there? Or does it have a continued value? And that's
a bit confusing. We must start talking about value, because no one's talking about deducting any capital value. We're talking about income here.
Yes.
Does it have a continuing income generating capacity? Isn't that the right question?
Yes.
Not does it have a continuing value?
Well, shares in a company have
agree
value
that,
because they produce income.
I understand that, but it's nevertheless important for the analysis to focus on that, because this is about income loss.
Yes. So what Lord Justice Bean is meaning that if you look at the value added bit, that is truly the bit that Mr. Rix would have added, and we say not insignificant from his day-to-day continued involvement. You can't make a testamentary disposition of that. It was a fact that goes in the context of lost years' claims and how one goes around assessing, is it the claim of the estate or how does one look at it? But it cannot be said, and it flies in the face of the primary facts which were not disputed, that this business just came to a halt because in December 2015, and would have come to a halt because Mr. Rix was no longer able to attend to it. And that's not because of a wholly new venture being started by his sons from scratch. which have provided a replacement income. They were able to take on the existing business, which was a going concern. Maybe they've done very well, but maybe they all would have done better.
But you say that's what the exercise should be. It should be,
Yes.
it should be either estimating by how much they would have done better, or if that's too difficult, estimating what the cost is of someone equally good who you hope would have made them do better.
Yes.
Yeah.
And that becomes a proxy for the loss.
Yeah.
And my own friend relied, it says the judge has found, as a matter of fact, that all the profits were generated by Mr Rix. Apart from the point I've already made, that would fly in the face of what we know about this business. That's not, in fact, what the judge says at paragraph 66 of his judgment. I've taken the court to it.
We'll take us to it again.
It's that 5 lines down. In my judgment, it would be wrong to regard Mrs. Rix's shareholding in the family business at the time of his death as being an income-generating asset, independent of the work and labour of Mr. Rix himself. But he's not saying, and could not say, that it had no income-generating capacity. He is saying that Mr. Rix was important to it, and we acknowledge that.
Well, it's part of the problem created by the absolutist submissions. At this point, he was dealing with the submission that there was no loss at all.
Well, yes, but he was also dealing with that submission in response to what we say was an absolutist approach, which is that you just look at the profits.
There we are. We needn't worry about that.
So we do say that there isn't this escape for this approach, which was adopted as basis one. My learned friend says that, repeats that the dependency is fixed at the date of death and nothing that happens thereafter can make any difference. And he says the only exceptions are death, remarriage, now removed by statute, and inflation. Well, that's, with respect, not... there's no basis for saying that is an exhaustive list. I've cited Lord Newberger and Lady Hale in Nower saying it's a conventional question of what is the loss, no more and no less. And therefore there must be cases. For example, if the deceased had been on a salary with a company which all unexpectedly goes bust just before trial, that would be taken into account in looking at what the expectation of his widow was at the date that he died, because the court now knows what otherwise it would have to speculate about. Or if, on the other hand, the company he worked for did so well it was handing out bigger bonuses, then that would be that would increase the dependency, because the court now knows what would otherwise have been speculative. And there is no support for the proposition. There's nothing in the Act itself, and there's nothing in the authorities, which says that it is only those limited categories of case which can be taken into account post-death. But, my Lord, ground 2, I've covered points I want to make. Yes, just a point about the retained profits. The retained, my own friend makes the understandable point that if we are saying it's the money received rather than the profits overall, and one way of doing that would be to look at the historic tax returns, he says that's wholly arbitrary. And with respect, I entirely agree with him that you might have, I've said this earlier, you might have a very frugal businessman who doesn't want to take any profits, or you might have an extravagant one who takes 100%, or sometimes even more than the profits of the business. The point I was making was simply that a way of looking at it in this case, and the burden is not on the defendant, is to look at the fact that over 5 years, the family income was, the source of the family income largely were the dividends paid out. And that's one way in which one might say that reflects what Mr. Rix himself, for example, regarded as the value of his contribution. Turning to ground 2, my own friend says, well, it's all, this is distinguishable from Kent and BRB and much closer to Ward and Newell. My point is not about the facts of the case, but that this case involves a shareholding in the name of Mrs. Rix, which is, whatever my own friend may say about it, is her entitlement indefeasible right? If leaving aside this case and imagining Mr. and Mrs. Smith in a similar situation and they fall out and they separate, would Mr. Smith have been able to demand her shareholding on the basis that he was generating the profits? No, the answer would no doubt be, well, it's a family enterprise and I've contributed my part indirectly. So we say you can't simply apply this mechanistically, this point. And Sir John May was making it very clear that the question for the court depends upon a careful analysis of the nature and legal incidence of the relationship. And with the Partnership Act, there's some scope for implied agreements, if there isn't a partnership deed setting out the rights. Ground 3, my own friend says, well, Coward and Claimant is different because in that case there were different income streams. Can I just make a point about Williams, because it may occur to your lordships, admittedly this is a basis 2 point, so strictly necessary, but that there was no deduction of surviving income in the Williams or the Cape calculations. But in both of those cases, the assets which provided the income or the profits that were shared from the property portfolio in Cape, from the merchant business and the property portfolio in Williams, were owned by the deceased and then inherited by the dependents, and so they were squarely caught. The defendants were squarely caught by Section 4 and couldn't pay them in aid. It makes no sense, we submit, to say that an income that was derived from a shareholding which was Mrs. Rix's and remains Mrs. Rix's should be left out of account. It is not covered by Section 4. Simply doesn't, the words don't allow for it. And to say that they are separate income streams, with respect, doesn't cater for the case, for example, where the wife or the husband, the surviving partner, may have their own investment income, for example. That's always taken into account. All you're looking at is the family income and seeing when you do the netting down, what has been lost to the dependent. It's not really concerned with putting a value on or characterizing the nature of the income of the dependent that survives. It's just a matter of looking at the income, comparing the position of the household income if the deceased had survived, and comparing it with the position as it is now. And so we do say that on any basis 1, basis 2, this is a discount that ought to be made at an appropriate point in the final calculation. Because I believe that has covered points I want to cover in any other matters.
No, thank you. Thank you both very much.
Yeah, thank you.
Very well. As counsel will know, but I'll explain to others in court, we will be reserving our decision. That's to say, we will go away and think about it. When we have reached a decision, judgments will be circulated to counsel in draft, so that they can agree the terms of a consequential order, if possible, and if they can't, so that they can produce short written submissions on the basis of which we can decide any disputed point about the constitution or about the consequential orders, and of course to draw our attention to any typographical or minor factual errors in the judgments. We will of course do this as quickly as we can, but it needs some careful thought, so it may not be extremely soon. Thank you both very much.